Welcome back, everyone, and welcome to our keynote panel, which I am delighted to be introducing. So we have, the aim of this panel is really to have some real blue skies thinking about the future of the data protection framework, and we have a fantastic lineup. Dr. Winfried, who is currently at the Ministry of the Interior in the Federal Republic of Germany working on open data, but probably better known for in data protection circles for running data protection landscape for many years, which has really been, from a sort of civil society perspective, really asking some and posing some really hard questions for data protection. So he'll kick us off. Then we've got Professor Bert-Jaap Koops from Tilburg, who needs no introduction, really, has been working for so many years in the data protection area with TILT and so on and so forth, and is very well known for a famous article on data protection reform with an Alfred Hitchcock title, which I'm sure will come up. And then Professor Nadja Purtova from Utrecht University, who is very well known for the law of everything. That's not her work. Well, it is her work, but it is the title of one of her most influential articles, and has been running a really interesting European Research Council project, again posing interesting and important questions about the nature of data protection in Europe. So I would say without further ado, but I should try and work out how to get Winfried's presentation up. It is here somewhere.
Should be there. It's already there.
It was already there.
Yeah.
It's there.
Yeah.
Yes. I will click that and I will pass you over to Winfried.
Yeah, hello everybody, and thank you, David, for this invitation to Cambridge. It's my first time here, and I would have never thought that it would be even possible to speak in Cambridge once in my lifetime. So I'm very thankful, and yeah, I'm honored to have a keynote here on this exciting topic. My engagement with data protection law commenced 2012. At that time, I was a member of the German delegation representing the federal government in the negotiations for the GDPR. Back then, the UK still was a member of the EU, as you all know, and the UK, the Netherlands, the Scandinavian countries, and the Baltic states. And Germany had built a like-minded group, as you do in these council negotiations. And our original aim was to create a more innovation-friendly, future-proof, and more reasonable, risk-based data protection law. As you all know, we failed with that attempt. Since then, I have developed a sort of love-hate relationship with data protection law. And since then, my drawers are laden with an array of fundamental critiques of data protection law and some ideas on how it could be improved. Yet the majority of those ideas have remained shrouded in obscurity. For voicing dissent against data protection norms borders on political heresy, at least in Germany. I'm not sure if it's the same in the UK. On the EU level, it is heresy if you criticize the GDPR. Still, I find myself as the last to dispute the necessity of reform. In this context, I must do this disclaimer. Serving the Ministry of the Interior as a civil servant, my perspectives do, of course, not echo the official stance of the institution. And I'm standing here and exercising my liberties of expression and academic inquiry, privileges that fortunately a civil servant in Germany is afforded. Thus, my presence here is a personal endeavor and requires a day's leave. Yet, addressing this assembly at your conference in Cambridge is not so much a sacrifice as it is a as I said already, a distinct honor. Let us, however, proceed with methodical scrutiny. The imperative for a reform of data protection law must be cogently articulated. I shall embark on the nearly impossible endeavor of highlighting 12 structural deficits. Maybe I will just do 10 deficits because we do not have enough time. Culminating in a rather sobering conclusion to put the end at the beginning. Nevertheless, the debate must held, and I'm therefore very grateful again to David Erdos for invitation to this conference. The assessment of the GDPR could not be more divergent. They range from gold standard to monstrous. Here are some quotes, primarily from German politicians, EU bureaucrats or scholars. Jan Philipp Albrecht, for example, who was the rapporteur for the European Parliament, sees the GDPR as the gold standard, and many concur in this assessment. Martin Selmayr, the then head of cabinet of EU Commission President Jean-Claude Juncker and a kind of puppet master, saw and sees a new era. Paul Nemitz, another EU official, says the EU is, because of the GDPR, the trust center of the world. And Isabelle Falk-Pierrotin, who was then the president of the CNIL, the French Data Protection Authority, claims that for them the GDPR is like a cathedral. On the other side, there is fundamental criticism. Thomas Hören, a professor of law in Germany, describes the GDPR as the biggest catastrophe of 21st century.
No.
Christoph Kuklik, a sociologist and journalist, diagnoses a digital counter-revolution. The lawyers Nico Herting and Jochen Schneider see the perfection of a dead end. And Caspar Bowden, the British data protection expert who unfortunately passed away, just observed a Frankenstein monster. Upon perusal of the documents issued by the European Commission, one might be led to believe that the GDPR resides in a state of unassailable integrity. You have to read these documents. Within these documents, one encounters assertions characterizing the GDPR as the, quote, gold standard. We had already that. Describing in laudatory terms as the, quote, fabric of a success story. Further, they extol the, quote, global upward convergence. When I read this term, I couldn't believe it. In Germany, it's even more strange, the Aufwärtskonvergenz, the upward convergence. So all the other countries of the world, now they are following the GDPR approach, and now we are in this global upward convergence. Wow. Alongside proclamations of a thriving data-driven economy and the European data space, a little bit doubtful if that is a realistic description of the European data economy. In stark juxtaposition to this optimistic portrayal, I proffer a perspective grounded in a more critical analysis. The GDPR creates tremendous problems. Here is the case for fundamental criticism. A pervasive legal ambiguity persists even 6 years after the GDPR came into force, evidenced by the excess of around about 50 preliminary decision procedures right now pending before the European Court of Justice. The GDPR creates huge bureaucratic burdens, of course. We see an impressive unwillingness to comply with the legal regime, and a phenomenon denoted in German as the Vollzugsdefizit, the enforcement deficit. And amidst the corona pandemic, a discord emerged between the imperatives of data protection and public health safeguarding. My impression is that the criticism expressed about the GDPR is only the tip of the iceberg. There is even more displeasure with the GDPR that remains unspoken. One reason for that muted dissatisfaction lies in the unrecognized structural deficits of the GDPR. And it is almost as if there lacks a language to critique the GDPR in this fundamental way. In an attempt to change that, allow me to enumerate, 10 or 11 of these structural shortcomings. First structural shortcoming is the one-size-fits-all approach. We have heard that already this morning. The GDPR follows this approach. Every controller has the same obligations. GAFA, Google, Amazon, Facebook, and Apple have the same obligations as your local bakery around the corner. The tax authority has the same obligations as the blogger, the amateur photographer, and the sports club. The pharmaceutical industry has the same obligations as non-profit organizations. The same obligations apply to all processing, whether it makes money or not, whether it is for profit or for the public good, whether it is for private or public purposes, whether it is an everyday process or a complicated algorithm. There is a little bit of grading, at least that was the original idea of the risk-based approach. But in the end, the risk-based approach in the GDPR is not very popular among practitioners and among authorities, and it only applies to technical and organizational measures, but not to the obligations of the GDPR. This one-size-fits-all approach is far too indiscriminate, and it is unfair. It does not take into account the skills of the controllers. It does not take into account whether the processing itself is protected by fundamental rights. For example, if you are doing research or if you are using personal data for religious reasons or let's take the fundamental right of art. And it is unnecessary. It basically treats low risk and high risk processing in the same way. The one size fits all approach is often like using a sledgehammer to crack a nut. Second structural shortcoming is the all or nothing approach. The GDPR follows this approach. If there is a personal data, all data protection rules apply. If there is no personal data, there is no regulation, at least on behalf of data protection law. This also is very undifferentiated. In the GDPR, there are more or less only two categories of personal data and sensitive personal data. The fact that I wear glasses is a sensitive data. My credit card number is not. That is also quite undifferentiated. By extending the concept of personal reference or the possibility to be identified, for example, to IP addresses, personal data become limitless. There is almost no such thing as non-personal data anymore, besides some industry data, but even they are often combined with those people who create these data, and then it become personal data. On the other hand, the GDPR does not cover when anonymous data is used and to enable re-identification or to discriminate against certain groups of people. Third, structural deficit, the prohibition principle. The GDPR enshrines the principle of prohibition. The German administrative law has a marvelous term for this. It's the Verbot mit Erlaubnisvorbehalt. Or, to be even more precisely, the Verbot mit Erlaubnistatbestandsvorbehalt. This means that processing of personal data is fundamentally forbidden unless explicitly authorized by legal provisions. This framework necessitates a labyrinth of exceptions, which invariably become battlegrounds for legal contention and ambiguity. This modus operandi is not merely restrictive, it is overtly antagonistic towards data processing. Rooted in the notion that personal data handling is suspect, if not outright socially reprehensible, it coerces even fundamentally rights-protected and socially beneficial processing into a perpetual state of defense. The implicit indictment of all controllers engenders chilling effects, stifling the exercise of fundamental freedoms out of a disproportionate fear of regulatory reprisal. Consider this illustrative extremity. It's a kindergarten in Dormagen, Germany, where a photograph was included in the parting documentation of a child, the blonde girl in the middle. In this scenario, the kindergarten was a public institution that would have needed a sector-specific law entitling it to process photos of the children. It's a common problem in Germany. There's huge discussions about kindergarten photos. Most probably the local kindergarten here, the local kindergarten law did not provide for such a legal basis. Yes, of course, they could have asked the parents for consent. But one cannot blame the people working for the kindergarten for foregoing the collection and documentation of consent from 36 parents. I counted the children. Daycare operators likely have more important responsibilities and do not have the time to document consent forms. This incident, while technically compliant, exemplifies the outcome birthed by the principle of prohibition, an unintended yet inevitable drift towards absurdity. The prohibition principle not only catalyzes such distortions, but propels a broader shift towards the privatization of the social sphere and the juridification of daily existence. It transforms the landscape of social interaction into a minefield of legal pitfalls, where the ordinary act of capturing and sharing a moment becomes ensnared in a web of regulatory constraints. Fourth structural shortcoming, the focus on input. The doctrine of data protection law remains fixated on the inception of data handling. The collection and the storage phases dominate its concerns. This focus on input starkly neglects the varied protection needs of individuals, rendering a nuanced approach to data rights unattainable. Such a singular preoccupation obfuscates the critical political discourse on permissible data usage parameters. The discourse on the legitimacy of specific data processing activities, whether they should be sanctioned or prohibited or allowed, is thus eclipsed. Moreover, the input-centric viewpoint fails to acknowledge the value generated from the output of data processing. The treasures unlocked through data analysis, insights that could propel societal advancement, remain undervalued, if not wholly ignored, under the current regulatory paradigm. Which leads us to the fifth structural deficit, blindness to the benefits. Focusing on data collection, input, obviously blinds us to the fruits of data processing, output. While the regulation is conversant with the purposes of processing, recognizes legitimate personal and public interests, acknowledges different forms of risks, and anticipates harms, it exhibits a startling obliviousness to the benefits of data processing. The concept of benefit, integral to understanding the full spectrum of data processing's impact, is conspicuously absent from the legal lexicon of the GDPR. The word does not exist in the GDPR world. The regulation's failure to incorporate benefit as a legal category, I don't know why it is doing that on its own. I think this is a time management thing. Huh? It exhibits the regulation's failure to incorporate benefit as a legal category underscores a grave deficiency, of course. It negates the positive externalities that data processing can unleash, ranging from innovative breakthroughs to enhancements in public welfare. By sidelining the benefits, the GDPR not only impoverishes the discourse around data protection, but also inadvertently stifles the potential for data-driven progress. Sixth structural deficit, the common good. Related to the topic, but not identical, with what I said about benefits, is the common good. The fact that data processing may serve the common good, or at least benefit indirectly, is only recognized in a few recitals of the GDPR. There is not enough time to read them here. It's 5 or 6 recitals in which the benefit or the common good is mentioned. But the wording here is pretty promising. Serving mankind, function in society, benefits of natural persons and society, legitimate expectations of society, increase of knowledge, new knowledge of great value, better research results. These words are written in the recitals. Fine words. However, they are also legal prose that can hardly be taken into account in the harsh reality of enforcing the GDPR. There, the focus is on the individual processing interest of the controller and the individual prevention interest of the data subject. 7th structural shortcoming, the objectification of data. The GDPR's architecture, tethered as it is to the processing of individual pieces of data, embarks upon a fundamentally flawed premise. It treats data as if they were tangible objects. The conceptualization erroneously imposes a model of scarcity, as though data were a finite commodity. Such a paradigm engenders a plethora of misconceptions. It propagates the belief that all personal data merit uniform protection, disregarding the variegated sensitivity and value of different data types. It fosters a widespread notion that individuals own their data in a possessive material sense, culminating in the slogan, "My data belong to me." This misapprehension fails to acknowledge the quintessential nature of data as information, which is information is incorporeal, information is not consumable, information can be reproduced at will, and information is non-rivalrous. This means that it can be used by many people at the same time. Information content and economic value are contextual. In the realms of big data, algorithmic processing, and artificial intelligence, the significance of individual data points often diminishes or becomes altogether irrelevant. I don't know what it's doing. Hence, the GDPR's insistent focus on the individual datum, what's the singular of data? Date, the individual date, misses the mark, failing to capture the essence and dynamics of information in the digital age. Therefore, the GDPR's focus on the individual date is not sufficient. What is needed is a regulatory perspective that recognizes the unique nature and potential of data in contemporary technological contexts. 8th structural shortcoming, the controller. The GDPR operates under the anachronistic assumption that there is one controller who processes the data in one central data processing system. We have talked about that this morning already. This model is discordant with modern digital ecosystems. Think of cloud computing, the Internet of Things, digital platforms, blockchain technologies, and other complex networks of actors. The legal frameworks within the GDPR designated to delineate responsibilities among multiple entities. There are only 2, processors and joint controllers. And those 2 are inadequate against the backdrop of today's global interconnectedness. In many cases, data processing can no longer be attributed to a fixed physical resource. The GDPR is based on old-fashioned concepts that no longer fit the problem. The purpose limitation principle, for instance, excludes serendipitous scientific discoveries. For example, the discovery of correlations. This makes me angry here. The GDPR the principle of data minimization excludes a priori processing based on the retention of data in the public interest. Ninth structural shortcoming, the Schutzgut misery. I am calling the Schutzgut misery. Schutzgut is another nice German word for which I have never found a proper translation until now. Maybe we will find one today. A literal translation would be the good that is protected. The GDPR does not even know what it wants to protect. As we all know, it is based on the fundamental right to data protection. And according to pure doctrine, any processing of personal data is an interference with this fundamental right. I have understood that. However, data protection alone does not indicate when such an interference is justified. This can only be determined if another protected interest, another Schutzgut, is added. In the 1995 Data Protection Directive, this protected interest was in particular, quote, the privacy of natural persons. The GDPR no longer even mentions privacy or private life. It remains unclear whether the GDPR protects privacy, protects the right to personality, protects what most German scholars still believe, the right to informational self-determination, or protects other rights, or wants to prevent informational asymmetry, or wants to do all this with one legal act, to protect all rights and freedoms. The term rights and freedoms is mentioned 77 times in the GDPR. However, if the GDPR is supposed to protect all rights and freedoms, this leads to an overload for controllers who have to take all these rights into account. And it leads to uncertainty and disappointment for data subjects when their expectation that the GDPR will protect all their rights and freedoms is not met. 10th structural deficit, the balancing tests. How many balancing tests does the GDPR contain? By my count, it's 82. Maybe if you do a recount, you will find it's only 67 or 82. It depends a little bit what you call a balancing test. But this means that there are 82 provisions in the GDPR according to which every controller must carry out a balancing of rights and interests between his rights and interests, the data subject's rights and interests, the third person's rights and interests, and the public interest. There are 3 fairness tests, 8 balancing of interests tests. That's what it wants to do. 2 compatibility tests, 11 adequacy tests, 30 necessity tests, 12 appropriateness tests, 3 proportionality tests, and 13 risk assessments. It's 82 balancing tests. The GDPR contains these obligations for every citizen, not only for state authorities who processes data, not just for the powerful companies or public authorities. In the absence of a precise definition of the GDPR's protected interest, the Schutzgut, there are also no clear standards for these various balancing tests. 11th point, cascade of preventive measures. The fundamental assumption of the GDPR is that there is no longer any such thing as trivial data. The law therefore never regards the processing of personal data as risk-free. It imposes obligations that must be fulfilled preventively. That is, before any processing can begin. Controllers must define the purposes of the processing, define their interests, seek a legal basis for their actions, balance rights and interests, comply with the transparency requirements, identify legal basis, provide information on remedies, comply with written form requirements, comply with the obligation to state reasons, meet the requirements of certainty, and document everything. And that has to be done not only by Google, but also by the hobby photographer, if he would comply with the GDPR. The GDPR is largely preventive in nature. If you are a controller, you want to process personal data, there is not just one current legal obligation, but a cascade of a total of, I counted them, 68 obligations, depending on how you count. It's a hypertrophy of obligations. Remember the less is more paradox. Too many obligations tend to undermine the will to comply. In addition, many information, documentation, and verification obligations impose, of course, bureaucratic costs on citizens, businesses, and administrations that are hardly offset by any measurable benefits. In summary, the obligations of the GDPR are likely to constitute an encroachment on private autonomy. As if the situation were not dire enough, the problem with data protection law is exacerbated. No, I learned this word this morning, but I cannot pronounce it. Exacerbated? By the legislative tsunami sweeping over the EU. I would like to mention only the Data Governance Act, DGA, the Digital Markets Act, DMA, the Digital Services Act, DSA, the Data Act, DA, the Artificial Intelligence Act, AIA, and the European Health Data Space, EHDS. All these legislative acts contain, more or less, of course, but all of them contain regulations pertaining to data. In a display of rhetorical acrobatics, they all avoid laying a finger on the sacrosanct edifice of the GDPR, a feat akin to squaring the circle. Their proposals orbit the domain of the GDPR. Sometimes they suggest modifications within its purview, yet they audaciously proclaim that they are without prejudice to the GDPR. DA, AIA, and EHDS shall not affect the GDPR. That's quotes. DGA, ODPSI, DSA, DMA, DA, and AIA are without prejudice to the GDPR. DA says in the event of conflict between provisions, GDPR shall prevail. AIA, DA, e-privacy, not yet decided upon, and EHDS at least admit that they complement the GDPR. And, well, health data, they at least realize that it further develops the GDPR. Why is this the case? One might venture an educated guess. No one wishes to engage in the laborious tangle with the data protectionists. And why does this present an issue? Well, even if legislative acts whose objectives are largely uncontested are unable or forbidden to amend the GDPR, how can we ever hope for a substantive reform to take root? What can be done about this unfortunate legal situation? Well, the law is what it is. A major overhaul, reform, or even revolution of data protection is unlikely. It is politically unenforceable. Unfortunately, it is also thwarted by the European Commission's monopoly on legislative initiatives. Marginal note, I wrote my PhD thesis on the democratic deficit of the European Union. Back then, 2000, I underestimated the importance of this right to initiative. Right now, it's only the EU Commission that can change this situation. The European Parliament is unable to do so, the national parliaments are unable to do so, and the governments of the member states are unable to do so. To get rid of this undemocratic rule was one of the good reasons for Brexit. one of the good reasons for Brexit. Perhaps a creeping process of rethinking will begin. At least we can currently see a move away from the one-size-fits-all approach. That was this one slide I did not show, I did not comment on. Here you can see the sector-specific provisions in those legal acts mentioned. Those quite a lot, meanwhile. So we have sector-specific regulation on data intermediation services, on AI systems, on hosting platforms, and so on. Yes, there is this tendency to realize that the one-size-fits-all approach is maybe not sufficient, but on the other hand, we have this, I call it gold standard paranoia. That means that people are anxious to tackle the GDPR, to even admit that it is not sufficient. Rules that treat all data-related issues in the same way are definitely not sensible. In my opinion, sector-specific rules would be better. The EU data spaces are a step into that direction. I also see a shift in the legal policy debate towards the benefits of data processing. Data trusts, data donation, data altruism are here some key words. These are still tender shoots, but the opening clauses of the GDPR would allow for the enactment of sector-specific regulations. Regulations on data use could be enacted. Data use in the public interest could be privileged. Benefit could be introduced as a category of data protection. The GDPR can also be interpreted in different ways, but you would need the people to do so, especially the judges. And I'm not very hopeful that the European Court of Justice will change its jurisdiction. If a case comes to the European Court of Justice, you know how it goes. Data protection will always win. Perhaps it will be possible to see data protection law not just as a right to prevent, but also to a right to turn it in a right to enable. Thank you.
Well, thank you very much, Winfried, for an absolute tour de force, despite the gremlins. And that actually also brings up from our very first panel, Vivian's point about, is the DPIP bill in the UK really dealing with the fundamentals and what might it mean to deal with the fundamentals? I think, we begin to see some real thinking around that in this panel. So I will now move over to an esteemed colleague who's commented on this a lot already, Professor Bert-Jaap Koops. I know time is short, so I will find his slides.
Yeah, but it's also open now.
And 1, 2, 3. Over to you.
Thank you very much, David, also for the invitation. When we prepared this panel, Winfried was the first to say what he was going to say, and he said, "You'll probably completely disagree." Unfortunately, I almost completely agree, so I will be telling a bit of the same story, but I'll tell it in different terms. I also have a disclaimer to make and a warning. The disclaimer is that this is not new work, as David was mentioning. I published a paper 10 years ago, and I'll be presenting largely what I wrote in that paper. That was based on the proposal for the GDPR, based on my expectations, what it would do. And although the GDPR has brought some things, good things, bad things, things have changed a little bit compared to what I expected. By and large, the story hasn't changed that much. I think there is still fundamental issues with the GDPR. So that leads me to the warning. I will exaggerate. For the sake of clarity of my argument, I will exaggerate how much problematic the GDPR is. So bear with me, but I'm trying to make a point, largely the same point Winfried has made. And we can see where we end up there. David already mentioned the reference of my article. I'm not sure whether you know the movie, and I have no idea whether this works. If there is an internet connection here, doesn't really work. It does work. So, in the next 15 to 20 minutes or so, I will be elaborating why I think the GDPR is dead. Based on fundamental flaws in the assumptions, in the objectives it wants to achieve. And for each of these objectives, I'll highlight 3 problems which together make clear that there is a fundamental fallacy in achieving those objectives. And at the end, although it's difficult to have good alternatives, I'll try to say something as what to do with Harry's body. The GDPR is based on several assumptions, several things it wants to achieve. From the 2012 document, where they highlight several objectives, the first and very prominent one is to put individuals into control. The GDPR aims to give people control over their personal data. The second objective is to simplify the regulatory environment, to reduce administrative burdens, to improve consistency. And a third objective was to have a comprehensive framework covering all areas. Each of these is problematic, to say the least. I don't need to say that much, I think, about the first, putting individuals into control, because that's a well-known discussion. Most people probably agree. It has already also been said this morning. But very briefly, the starting point of informational self-determination, of putting people into control, is that consent is a very important legitimating ground, particularly in the private sector. And there are data subject rights which they can exercise in order to make sure that controllers only do what the data subjects want them to do with their data. The first problem is that consent is a myth, at least when you have effective and meaningful consent. There is a bit of a contradiction in terms there. If you want to have effective consent, it needs to be manageable, practical. People need to want to do this, to give consent, meaning that you have to have very smooth procedures for giving consent. If you want to have meaningful consent, on the other hand, you need to provide them with information. You need to make sure that when they click a box, they really mean to click the box and they really mean to give consent. And those two can hardly be really matched together. So there is a lot of rhetoric on consent, I think, that is somewhat problematic. But also exercising control over data is extremely difficult. Who of you feels in control of their personal data out there? And you are probably more aware of data protection and the fact that so many data are being processed about you than most other people out there. So people don't exercise control over their data. Also, informational self-determination, having control over your data, doesn't work in the public sector simply because citizens can't choose what the government does. The tax authorities need to process data, and citizens might well object to that, but they don't really have a say in what the tax authorities process about them. They have a few rights, namely that the data that are processed about them are proportional, are accurate, but they don't really have a say in the purpose or the means of data processing by the public sector. So all in all, there is very little informational self-determination, meaningful informational self-determination in the private sector. It's a concept that doesn't really work in the public sector, and so focusing on user empowerment is a flawed assumption in the GDPR. On the other side of the equation, the controller. The GDPR puts rather much faith in controllers, despite all the discussions we just had on enforcement, and we will have a panel on enforcement later on. Many data controllers are actually willing, law-abiding institutions, organizations, who in principle would like to be compliant with the GDPR simply because they want to be lawful and good abiding citizens. But data protection law is pretty complex. That was already the case with the Data Protection Directive. Many criticisms were voiced on that. I recall evaluations that were done of the Dutch data protection laws of 1993, I think, and again in 2008. Both evaluations concluded that the data protection regime was extremely complicated, a lot of concepts that were hard to interpret, and it was a complex law only for specialists. So then enters the GDPR. Instead of 34 articles that the Data Protection Directive had, we now have 99 articles. So if you want to simplify the regulatory regime, tripling the amount of rules is not really maybe the best approach. Particularly not if many of these provisions have cross-references, nested cross-references. Sometimes when you want to understand the law, you look at a provision which refers to another provision, which refers to another provision, which refers to another provision. And by then, most even lawyers and most even data protection lawyers will have lost track of what actually the law says. So it's extremely complicated, and the GDPR doesn't really simplify that. Another issue, I think, is that the GDPR has more ex-ante obligations, already highlighted the preventative approach. There is a requirement to do data protection impact assessments, at least for risky operations. There is a provision of data protection by design and by default, which in principle are very noble and good provisions on paper. Whether they are actually functioning thus in actual practice, I'm wondering, because most of these DPIAs are done, I think, as tick box exercises, was already mentioned this morning. And I think a lot of GDPR compliance is that, just ticking boxes to comply with the rules, at least on paper, without thinking what actually the data processing is doing and what the aim of a DPIA is, forcing someone to think, this is what we want to do, these are the consequences. Is it really necessary to do it this way? Maybe we can have the same goals, but with more privacy-friendly, more data protection-friendly, more limiting measures of data processing. I'm wondering to what extent that is being done. It's more a matter of just paperwork. Also, it's not only preventative approach, it's also the accountability. There's a lot of requirements of documentation. Data controllers need to keep records of their data processing so that they can be held accountable. Also, that I think is largely a paper exercise. Disclaimer, I work in academia, I don't work in practice, so I don't know exactly how much this is being done in practice, but my impression is that GDPR compliance, to a large extent in practice, is still that tick box rule compliance. It's not really data protection in the sense of protecting people. Also because it's difficult to know what actually you want to protect. It's difficult to find the Schutzgut, the legal good that actually is the core of the GDPR, because it's all over the place. All rights and freedoms in principle should be fostered by having good data protection practices. If you want to protect all rights and freedoms, you don't really get much of a guidance what to do in concrete data processing operations. So all in all, the law has only increased in complexity, I think. There is more paperwork, and overall it leads to be controllers to be rule compliant, but not people to really care for data protection, to think about it. So ultimately, I think the data protection law is somewhat of a living dead creature. It seems to live, but it's lacking a vital spirit. The third objective was to have a comprehensive framework regulating everything. Again, that repeats what Winfried has already said, the one-size-fits-all approach is one fallacy. Because it's such a complex law, there is a huge discrepancy between law in the books and law in action. That was already the case with the DPD, with the Data Protection Directive. I think the GDPR has possibly only increased the gap between what the law on paper in the books says and what the law actually in actual practice does. It will be very hard to find any institution that is fully GDPR compliant, simply because it's almost impossible to comply with all the rules. So there is a huge disconnect. What the legislator has done, because this was already an old complaint of data protection law, is do more of the same law. Now we have the Data Protection Directive, but now really Data Protection Directive tripled. So more detailed legislation, more complex legislation, but also the GDPR has expanded in scope, incorporating certain problems that were alien to it. The GDPR also regulates, for instance, profiling. It also regulates, for instance, data portability, issues that I think are not really data protection issues, but for some reason or other have ended up in the GDPR, whereas to my mind, they fit much more in sui generis legislation for profiling, for automated decision-making. I think it would make much more sense to have a sui generis legislation for that. Things like data portability are really a consumer protection issue. So you could look at consumer protection law. Other things are also maybe more discrimination law problems, administrative procedure law principles could be helpful. So there are other bodies of law that we tend to overlook simply because the GDPR is such a cookie monster. It just swallows everything that it sees and tries to present everything in terms of there's a data protection issue here, because you always find an angle. There are always data that are being processed, so you can always find anchors in the GDPR to address this. But that doesn't mean you solve the actual problems. And related to this, because it's such a comprehensive, complex law that is difficult to see what actually it is for, it has a communication problem. The GDPR is generally seen, maybe not by you, but most people out there, as a negative, prohibitive law. That was already also mentioned, I think. Even data protection experts or people in practice often have more as a default position, you cannot process data unless you have safeguards, etc. Whereas in principle, you could also see it the other way around. Data protection law is very agnostic to data processing. You can process any kind of data that you want, as long as you do it in a reasonably proper way. So you could frame the same data processing operations from a positive note, but this is not the way that people perceive data protection. And I think this is one of the underlying problems why there is so little compliance in real protection terms. And I think underlying this is also that it is very much a command and control type of regulation, really hard law, whereas there are other instruments in the regulatory toolbox that you can also use to foster data protection. If you look at Morgan and Young's 5 tools of government, besides command and control law, you have competition, you have code, so you can use technology to solve or to regulate behavior, which is there in the GDPR, but the requirement to have data protection by design is again a legal requirement, not a technical measure. Consensus, communication are other types of things, and so it is a matter of not only looking at the sticks, at the negative incentives, also looking at the carrots that you can use to stimulate people to better protect the rights of people. So altogether,
Yes.
I think the scope of data protection law has expanded, maybe to the point of breaking, and I think Nadja Purtova will follow up on that. There is too little attention for other regulatory instruments, and altogether, the GDPR is a bit too much of the default go-to solution to internet problems. All internet-related problems are seen through the lens of data protection, whereas they might be much better solved by consumer protection law, administrative procedure law, sui generis law, etc. So, what to do with Harry's body? No one has an idea. If you haven't seen the movie, have a look, because it's great to see the body being moved around all over the place. I don't really have an answer what to do with Harry's body. You can see that from an outsider's perspective, and maybe you in the UK feel somewhat as an outsider to the GDPR, as a comedy. It's nice to see Europe struggling so much with the corpse, but being an insider and also as an academic in my darker days, I am a bit more pessimistic of the situation. It's not nice to have a dead body of law. So what to do? One option is to try and resurrect the dead body. And I think, and this is one possible way forward, although it's not politically realistic, but I'm an academic, so I can have blue skies ideals. Instead of having 99 articles in a very complicated rule-based law, why not have the OECD principles? 8 principles of data processing, principle-based legislation as the core, and then see how practice works out. And of course, it's not only a matter of you have principles and then you have practice. There's a lot of things in between. But having a law that focuses on the core principles rather than a whole body of rules, ultimately, I think would better serve the spirit of data protection rather than the letter of rule-based. So look at the forest rather than all the trees that block you from seeing the forest. And besides command and control rules, also look at other regulatory instruments than hardcore law. We can also say, well, nice try, GDPR. May it rest in peace, but we can solve issues elsewhere. So we can, for particular problems such as cookies, such as automated decision-making, make sui generis laws. Nothing prevents us from that in principle, except that if you have references to that, it leaves the GDPR intact or it only complements the GDPR. There might be some issues there. But I think we can also look and bet our cards on other horses than data protection law to solve problems, to protect people from informational harms. And another approach, I think, that is important, also politically not very realistic. Governments the regulators, but also administration, should serve as a role model. If we enact laws forcing private sectors and citizens to comply with a whole body of laws, at least the public sector itself should also comply with the law itself. You would hope that the administration would be law compliant. If they take the GDPR seriously, the government should minimize its data processing. The government is not doing that, certainly not in the UK, I think, it's my impression, but also not elsewhere. Most governments are big government. They want to collect as many data as possible. So it's completely at odds with the whole starting point of the GDPR, data minimization. If governments would enact real restraint in data processing, maybe they would serve as a good example, and maybe that would be a good starting point for the future. Thank you for your attention.
Thank you very much, Bert-Jaap. I mean, an incredible amount of food for thought. We're going to push on because time in this keynote panel is really short. So last but by no means least, Nadja Purtova, who's done the most recent large-scale Research Council project on precisely this issue of the scope of data protection, is coming up next. So I will, again, find her slides and pass you over to her. Nadja, there you go.
Thank you so much, David. Thank you so much for inviting me. It's such an honor to speak at this conference and especially follow up on the previous two talks. There is, what can I possibly add? But I will try. So in my talk, I will focus specifically on the challenges and failures of personal data-centric legal protection against information wrongs and propose some ideas about what to do to correct those failures. And the talk is based on the work that I've done with my wonderful team of the ERC InfoLeg project. So the talk will be primarily based on this research that I've done together with Dr. Bryce Newell, as well as on a couple of other papers that I'll mention. So, well, the starting point is very much known in this room. Personal data is a trigger concept of data protection law. When personal data is processed, data protection law applies. When it's not processed, data protection law does not apply. However, there are three problems associated with this personal data-centric system of legal protection against digital harms. One, over-inclusiveness, then paradoxically, under-inclusiveness, and then finally, the quality of law or regulatory imprecision. Speaking of over-inclusiveness, now, as you know, the scope, the material scope of data protection law is very broad. The concept of personal data has been interpreted by the Court of Justice in such a way that, at least in theory, a lot of things can be sort of put within that material scope of data protection law, and it's a good thing. It has been used by digital activists, digital rights activists, to tackle all sorts of digital harms. So I call the GDPR sometimes the defense against the dark arts, dark digital arts. So for instance, the GDPR right of access has been used against Uber and Ola by the platform drivers to challenge the robo-firing. The Italian Data Protection Authority has used the GDPR last summer to ban ChatGPT on the territory of Italy for a short period of time in any case. And while the formal reason for the ban was that the training data that went into basically training that large language model was possibly not processed with a valid legal grounds, the actual concerns that the Italian DPA voiced was that the ChatGPT exposes children to content they cannot adequately process. So then the third picture here is a portrait of Aleid Wolfson, who is the chair of Dutch Data Protection Authority, who in one of his speeches expressed his view on the role of the Data Protection Authority as the watchdog of fundamental rights, all of the fundamental rights on the internet. That's quite big shoes to fill. So, and I do have all the sympathy, and I do appreciate the beauty of the cathedral, which is the GDPR. At the same time, so the cathedral might be crumbling in places more than one. So as I said already, the concept of personal data is very broad, that it makes, more difficult to demonstrate convincingly that some piece of data is not personal data and will never be personal data. The other way around. And so everything is personal data, to exaggerate ever so slightly. Everybody is a controller. Yes, despite the fashion ID, there are still, so to assign a role of controllership, one doesn't need to have access to data. Well, one doesn't even have sometimes to be aware that personal data processing is taking place. No written directions, no written directions to process personal data are necessary, according to Jehovah's Witnesses' decision to make somebody a controller. And then this is all paired with the very intensive system of compliance. So apparently 82 balancing exercises contained within the 99 articles of the GDPR. And this all together, if you take the spirit of the data protection law seriously and aim to comply with data protection law every time it applies, and aim to enforce data protection law every time it applies, the system will crumble. So, Advocate General Bobek, among others, very aptly pointed out that the GDPR is firmly on the way to become one of the most de facto disregarded pieces of European legislation. As much as it hurts me, I think he's right. Now, at the same time, paradoxically, the system of the GDPR is also under-inclusive in a sense that the legal protection is not applied where it should be applied. So the case law of the Court of Justice on material scope and on personal scope of the GDPR is very complex, and understanding it requires costly expertise that many controllers do not have. They are not even aware that they are controllers or that they process personal data. So while some might not have the knowledge about data protection law, some have a little bit too much knowledge of data protection law that allows them to strategize and basically build compliance strategies that take them, well, or at least strategies such as privacy-enhancing technologies, synthetic data. I do not entirely buy the argument that these strategies lead to anonymization, but many controllers try to propose such arguments and then succeed without proper enforcement. But then sort of to add further to the complexity, now actually the scope, the meaning of personal data, it's also quite fuzzy. Yes, we do have the case law on several elements of the concept of personal data, but then the opinion of Article 29 Working Party, which is still the primary sort of source of interpretation for the controllers on what personal data is not binding. So the court basically can deviate from that interpretation anytime. The case law of the court itself is contradictory. Sort of, especially, we all know and appreciate the decision of the ECJ in the Novak, where it sort of followed the interpretation that data relates to a person by reason of content, purpose, and result, and that went directly in contradiction to the earlier judgment in YS and others versus the Ministry of Immigration of the Netherlands. But Novak does not explicitly reverse the judgment in YS, so it's still very unclear what it's still very unclear what the relating to data subject means. Now, until last week, we also didn't quite know what identifiable natural person means, because the sort of general court put a little bit of mud into water in its Olaf decision. And then data protection law also does not apply to group data, while a lot of damage is done on the level of groups. So as a result, what we get is a diminished quality of legal protection. So personal data is not doing very well as a target, as a trigger of legal protection and as a regulatory target. And the purpose of our project was to try to think how we can do it differently. So find any other ideas around which the legal protection against information-related harms can be organized. So, with our approach basically was formed by two perspectives. First, we looked at, well, how is legal protection structured? How do we build legal protection? And the second part of our perspective was to understand information in law. Well, since the GDPR is in business of regulating processing of information, it will be also good to understand how does information impact the world. Now, to start with how legal protection is organized, we looked at regulatory theory, legal theory, and basically it all boils down to, for the law or any regulatory measure to be effective, at least on the level of design, it has to regulate something that is in causal connection with the desired outcome. So at the core of every regulatory instrument, including the GDPR, there should be a good understanding of causal processes that they want to regulate. Now, the thing with the causal processes is that they change because technology changes, society changes. Also, our understanding of those causal processes changes, and we might discover that, say, the understanding we had previously was wrong, for instance. And so the lawmaker, the regulator, should be in this constant process of re-examining whether the ideas about causal processes that underlie regulation are still correct and still sort of match the reality. Now, this is the regulatory theory. The second theoretical perspective was information or understanding information. So the GDPR obviously operates with information concepts. Personal data is defined as information. Yet in law, the law basically is notorious for the total lack of, for its under-theorized use of information concepts. Now, one of the reasons that the law does not have an anchor in theoretical understanding of information is that, well, there are about thousands of those theoretical understandings, basically a huge range of non-legal disciplines, ranging from, say, archival studies and information studies to physics and biology, have a definition of information. But basically, there is this body of scholarship, which we roughly call information studies, where sort of people try to bring all these insights together. And so two scholars, Kapura and Herland, if I pronounce his last name correctly, have basically systematized those various approaches to what information is. And they distinguish three ways in which information is understood. First is semantic. Within this semantic school of thought, information is something that has a meaning to a cognitive agent, to a human. For something to be information, a human has to process it, and then when the meaning is sort of absorbed, it results in knowledge, and the knowledge results in wisdom. Yes, and then there are all sort of little branching outs of that semantic school of thought. For instance, some within this school of thought only think that only truthful information is information. But this is the conceptual core of it: is there is information when there is meaning attributed to it by human cognition. Yet there is another approach to what information is, where the meaning to a human is irrelevant. And for instance, an example of this syntactic approach is Shannon's mathematical theory of information, where information is defined as statistical probability of a sign or a signal being selected from a given set of signs. There is another sort of branch within the syntactic understanding of information, natural information, where, for instance, scholars of biology or physics say that the entire universe, planets, living organisms are made of information. For instance, DNA, it forms living organisms. So within this syntactic or statistical approaches to information, information is something that sort of forms reality or makes change in reality. And yet there is a third approach to what information is, which basically says, despite the fact that semantic and syntactic seem very incompatible with each other, we should actually, we should not be in business of arguing which concept, which understanding of information is correct. The concept is not true or false. The concept is just more or less useful in a certain context. And so we should consider the various definitions and the various approaches to information in this Wittgensteinian family resemblance kind of way. They might not necessarily share the same core, but when you look basically at all of them, there will be some sort of other common thread connecting them. And so, for instance, Luciano Floridi is basically his view on what information is falls under this functionalist view. So he says that information is three mutually compatible phenomena. First, information about reality, so it's semantic information. Information as reality, as patterns of physical signals, such as DNA or fingerprints, and information for reality, instructions like genetic information, algorithms, and orders and recipes. So, what do we draw out of this? Looking at those three approaches to what information is, there are basically two semantic cores of what information is. First, semantic and syntactic. So, and consequently, there are two ways in which information impacts reality. One way is semantic way through the cognitive interpretation. So when an individual learns some piece of information, for instance, or interprets, understands it. And then another distinct way in which information impacts reality is through change in reality, or the causal role in producing a measured function. So, for instance, gossip is an example of this causal process which involves cognitive interpretation. You publish something in the newspaper, some juicy details of somebody's personal life, and so the harm of that is associated with the cognitive process. People came to know something that the hero of that story didn't necessarily want them to find out. At the same time, information, for instance, in the shape of DNA, forms, brings a change in reality by, for instance, forming a fetus. Or computer code makes a change in reality because it brings a machine into action and makes it do, basically fulfill certain tasks. So there are two fundamentally distinct causal processes that are associated with information. And so it leads us to conclude that not all information-related wrongs are created equal. Some information wrongs are created as a result of cognitive interpretation by people, cognitive processes, and some are what we call meaning-driven wrongs, and some of them are they occur regardless of the meaning that information might have to a human, and this we call meaning-agnostic wrongs. Now, just to make this concept a little bit more clear, meaning-driven wrongs, they meaning-driven wrongs hinge on the meaning information has to a human. They arise when meaningful information about a person or a group of people is communicated or is known to others who access, analyze, or use that information. So this more conventional view on privacy wrongs, for instance, is a good example of these meaning-driven wrongs. Now, Sphere's theory of privacy describes this privacy wrongs when, say, information from an intimate sphere of a person is shared with others who, or Mosaic theory of privacy says that, individual bits of information might be innocuous and not say anything sensitive about a person, but when combined, they might disclose something belonging to private sphere. And then Bert-Jaap Koops also proposed his own theory of mosaic spheres of privacy, when basically those two theories are superimposed on each other. But then also conventional discrimination is a good example of meaning-driven wrongs. So people are treated unfairly based on their characterization along the known social categories. For instance, race is a socially constructed phenomenon, is perceived by human cognition, and then a human organization acts on it. Now, meaning-agnostic wrongs occur regardless of whether or not information has meaning to a person and what that meaning could possibly be. Meaning-agnostic wrongs, they arise as a result of information practices. And this is especially so after this algorithmic turn, where information makes sense in a fundamentally different way. So for information to impact people, it doesn't have to be processed by a human or understood by a human. So these kind of wrongs do not rely on cognitive interpretation. An example of a meaning-agnostic wrong is, for instance, algorithmic discrimination, where the semantic link between a certain characterization of a human and unfair treatment is broken. So this is connected to the research on the so-called algorithmic or calculated publics, where algorithms basically group people into categories that are not socially constructed, that are not known to us. And basically, information impacts people, but the meaning of that information is irrelevant. Consumer manipulation is another example of meaning-agnostic wrong. It does not matter what kind of information fed a profile that enabled consumer manipulation. What matters is that manipulation happened. Now, so there are these two fundamentally different causal processes that also require different regulatory approaches. And so regulation that is targeting meaning-driven problems should be separate from regulation that is targeting meaning-agnostic problems. So let's look at how the GDPR is doing, taking into account all that. Now, the GDPR disregards semantic and syntactic distinctions. So historically, data protection law operated with the term information perhaps in a syntactic meaning, but it also happened that now examples of syntactic information such as IP addresses, cookies, DNA have been considered personal data. Now, the GDPR also targets a very broad range of problems, which includes meaning-driven, such as traditional privacy concerns, and meaning-agnostic, such as automated decision-making, for instance. Now, the concept of personal data equally includes semantic and syntactic data, semantic and syntactic information, and this is especially evident in this element relating to information. Personal data relates to an actual person by reason of content when it is about a person. So this is an example of semantic information, or relates to by reason of purpose or effect when this information is processed with a purpose to assess or impact the fundamental rights and interests of a person. So here, the meaning of information is not important. The GDPR covers both syntactic and semantic wrongs and causal processes, but how is it doing? Is it working? Now, in another paper with Ronald Lanus, we did this intellectual experiment. We looked at whether or not computer code can also, under some circumstances, be personal data. So we applied the case law of the Court of Justice. And yes, computer code, our conclusion is that the computer code can be, under some circumstances, personal data. It is information, yes, relating to people. Well, we describe how, yes, are those people identified or identifiable? Yes, they are, sometimes. So our conclusion when we established that code sometimes is personal data, well, does it lead to absurd results? Not necessarily. In fact, most provisions of the GDPR, when applied to computer code, actually make sense and even contribute to the level of protection that currently exists. And the general principles of data protection law, of course, general principles and open to interpretation. Well, some provisions, such as the principle of data accuracy, is clearly aiming at the semantic causal processes because, well, to assess whether or not information is accurate requires cognitive interpretation. So applying data protection law to syntactic information and syntactic process in principle does not lead to absurd results, but the fact that it doesn't lead to absurd results does not mean that the GDPR solves all sorts of problems, including the problems resulting from syntactic processes effectively. So what I wanted to say with this picture is sometimes when a blindfolded child and the children's party can also hit the piñata successfully. But the child without a blindfold, sort of knowing what she's doing, will have much more success at much less sort of effort and cost. So the fact that GDPR sometimes, when applied to syntactic information to resolve meaning agnostic problems, sometimes leads to positive change, does not mean it is the most effective and most precise way to do that. And if the GDPR scope, material scope, is broad, in combination with a broad personal scope and intensity of compliance obligations, perhaps this divide between meaning-driven and meaning-agnostic is the place where we draw the line. How much time do I have? Or none? Okay, what does it mean for reform? Well, obviously, I will be very short. To regulate, it only makes sense to regulate semantic information to address meaning-driven problems. And you do it by, for instance, well, because you cannot regulate cognition, that would be very intrusive. The next best thing to do then is to regulate access and communication of semantic information. What about meaning-agnostic wrongs? Regulating meaning-agnostic wrongs, focusing on information, just any information, would be too broad and imprecise because now those meaning-agnostic wrongs, they materialize in many ways. So we have to narrow down the regulatory focus some more, but focus on personal data to regulate those meaning-agnostic wrongs is not productive in the sense that it distracts attention to the debates on whether or not a person is identified or identifiable, whether or not the information relates to a person or not, instead of looking at what exactly the problem is. So this meme, there was this video of you were asked to count how many times people in this bunch passed the ball to each other. And while you were counting, basically, then the next thing was that they would ask, and have you noticed the gorilla? What gorilla? You kept your eye on the ball. So you kept your eye on whether or not identification was reasonably likely to happen by a controller or any other person and forgot about the actual problem. So meaning-agnostic wrongs have to be prevented by regulation which focuses on problematic practices. Now, what practices? Bert-Jaap already talked here about sectoral legislation, for instance. So I'm here with him. I've heard a lot of arguments, indeed, that, for instance, what stood on the way of modernization of consumer protection law or administrative law or procedural law was exactly this kind of thinking that, oh, this is a digital problem, this is something to, for the data protection law to think about, but this has already been addressed by data protection law. So consumer protection law, other sort of existing sectoral legislation needs to be updated to account for the digital developments. But also, I think what needs to underlie this sort of sectoral legislation is a baseline of general principles regulating design and use of computer code. Why? Well, because the data protection law evolved in parallel with the evolution of computing technologies, and the computer code actually presents certain technology-specific problems in a sense that the outcomes created as a result of use of code are the code presents a challenge of scalability and stickiness of outcomes. Code amplifies broader societal problems in a unique way. So, for instance, when a faulty rule is translated into code, it applies immediately to thousands of people subjected to that rule. And then in another paper, we explained why exactly these have to be general principles of code as opposed to regulation of code akin to the GDPR. Braithwaite, an author working in empirical regulatory studies, argues that in the context or in the highly dynamic context with high economic stakes, the more precise the regulation is, the less the chances are that the regulatory goals will be achieved. And this is because the complex, highly complex rules, highly specific rules, serve not so much as deterrent or the regulation of behavior as the signposts for the industry to maneuver around the legislation. So I don't think I have any time to, no. So sorry for breaking the rules of time. Thank you.